Evrostroy Grupp.
My Lords, I appear for Vendort, the appellant. It's Vendort Traders Inc., which is a British Virgin Islands company, together with Mr. Jeremy Child of Harney, Westwood and Regals.
Yes, now you're going to have to keep your voice up.
Indeed. I have no opponent,
No?
and I think the due formalities were completed to permit my opponent not to appear.
Well, you can take it that we've read the papers, and there are two quite short areas which you have to address.
My Lord, yes. If I could ask, what I propose to do is just go to the arbitration ordinance 1976 in the British Virgin Islands, and after that go to two main authorities in the British Virgin Islands about the enforcement of foreign awards in the context of applications to wind up companies.
Yes.
And then I was going to briefly review the facts of the case, and then go to the judgment under appeal and the award to point out my first point, to deal with my first point, which is that the judge proceeded to deal with the merits of the challenge to enforcement of the award when he shouldn't have done so.
Can you explain in a nutshell why this alleged fraud is relevant? Let us suppose that the fraud was admitted in its entirety. Why would that entitle you to succeed?
It would entitle me to succeed because of the nature of the fraud in this case, which is about, it's an allegation of perjury, that a key witness
Yes, but why is it relevant? I mean, you can't set aside an award or challenge an award simply on the ground that there's a fraud knocking around somewhere. It's got to be relevant to the liability. And why was this relevant to the liability?
It was relevant to the liability because of the role that the witness played, or was played in connection with the decision in the award. It's Mr.
But you've got to have some evidence on the substantive point of a variation, which, as I understand it, the way you seek to avoid payment of the balance of the price. Is that right?
Variation is one aspect of it. There were other arguments put in the arbitration.
Yes, but what is the aspect you rely on now?
The aspect I rely on now is that it is a public policy objection.
But what is the public policy?
That in circumstances where a foreign award has been rendered and influenced by perjured evidence, which...
Got to be perjured evidence which goes to some issue that would have made a difference, and the only issue that would have made a difference to your liability to pay the balance of the price, since you're keeping the shares or claiming them, is, as I understand it, the suggestion that there was some effective forgiveness of the balance of the price, i.e. a variation apparently without consideration. Is that right or not?
The way in which the case was put in the arbitration was that the shares, the ISCOG shares,
Yeah.
which were the subject matter of the SPA, Share Purchase Agreement, had been acquired by Evrostroy from a company called Finvest, which was under the control of a gentleman called Kozlov.
Right.
And Evrostroy subsequently, not very long afterwards, sold those shares to Vendort,
Yes,
my
and
client.
there's no dispute about that sale, is there?
There is no dispute about that. And Mr. Kozlov was also in control of Vendort at that time.
Well, so presumably, I mean, it's also your case that he was in, I mean, it always has been your case, it's your case in the Russian proceedings, isn't it, that he also controlled Evrostroy at that time?
That's precisely the point, and that was argued in the arbitration to show that it was an intragroup transaction.
Yes.
And other evidence was relied upon in the arbitration to show that because it was an intragroup transaction, the debt was not, in fact, due or had been waived.
That's what puzzles me. I mean, your whole complaint as Vendort is that there was a fraud whereby somebody tried to deprive you, Mr. Kozlov tried to deprive you of the shares, presumably at an undervalue, but whatever. Now you're saying that an intergroup transaction can legitimately be inferred or may have existed whereby you acquired the shares at an undervalue from Evrostroy. Well, aren't you advancing a case that you were party to acquisition at an undervalue, since you said repeatedly how valuable these shares were in the Russian proceedings? You haven't suggested that they weren't worth the price which was named in the SPA. I mean, surely the logical explanation of the situation is that part of the price was paid, and the balance was the subject of the assignment by Evrostroy to Carnarvon and other companies. I forget quite what the chain was, but down that chain, which is the chain of transactions which you have established in the Russian proceedings were fraudulent. Once that goes, then you can't have your cake and eat it. You can't avoid the assignment and avoid paying the original price.
Arguments were advanced in the arbitration, and we would rely on them once more.
But the arbitrator pointed out, and it still seems to be the case, that you've got no evidence at all of any variation. On the contrary, what you've got is an evidence of a purported assignment which postulates that the full indebtedness existed. Now, you say the purported assignment's fraudulent, and you succeeded in the Russian proceedings. So you disregard it, and the original debt is valid.
May I go to the award to
Yes, do.
look at exactly what
I mean,
was?
The award is not, one may say, I think, an easy document to follow.
It's in volume 3 at page 271.
Page 371.
271.
271.
We can go to page 277,
Yes.
where the arbitrator summarizes Vendort's position and says Vendort alleges that there was an amendment to the agreement by mutual consent. According to the alleged amendment, Evrostroy decided to waive the remainder of the purchase price for the shares. No explanation is offered as to why this may have happened, nor any documentary evidence is provided to support this allegation. And 2, he goes on to say, as evidence, Vendort offers A, the fact that the shares have been transferred, allegedly waiving the need for total payment, and B, statements made by Mr. Mamporia during the criminal proceedings against Mr. Kozlov in the Presnensky District Court. These factual allegations and intended defences to non-payment will be discussed infra. The new facts that have emerged since those initial Russian proceedings, which are referred to here, are that a gentleman called Mr. Koltsov came to light. He came to light in the second Russian criminal proceedings. If one looks at the way in which Mr. Mamporia put his evidence in the arbitration, it's as follows. He says that Mr. Koltsov was a real person, and that Mr. Koltsov was active in the negotiation of the share purchase agreement, and that Koltsov spoke to him about the transaction and the payments that were made. It transpired in the second criminal proceedings that Mr. Koltsov was not so active. The Russian prosecutors had been able to identify who Mr. Koltsov was. He was a young man whose identity had been used for the purposes of signing documents.
Yeah.
And the default, the defect, we say, in the evidence that Mr. Mamporia gave to the arbitral tribunal was to maintain that Mr. Koltsov was a real person. He tried the same, he gave similar evidence, a real active business person, which he wasn't. He tried to give the same evidence in the Russian criminal proceedings, and the court there didn't accept what he had to say about that, because Mr. Koltsov was called, gave evidence, and said that he knew nothing about the transactions to which Mr. Mamporia was adverting.
Yes.
If I could ask you to go on in the award to page 288. Top of that page is a subheading Vendort's position. And 41, 42, move down to paragraph 43. In other words, the respondent argues that the SPA has been modified or replaced. Alternatively, the claimant has waived its rights under the SPA to seek payment from the respondent and or is stopped from doing so. 44, Vendort further raises defences based on public policy, set-off and frustration, and contends that the evidence before this tribunal, including that provided by the case witnesses, supports its position. It further submits that these proceedings have been initiated as part of a sustained assault carried out in concert with others on the respondent's ISCOG shares. The context here is that if Mr. Kozlov was indeed the person behind Evrostroy, which is an inference we would ask the court to make in the light of its examination of the evidence that Mr. Mamporia gave in Russia, which transpired to be, which was not accepted by that court.
Why does it matter who controlled it? The arbitrator found that there was no evidence of a variation. The variation seems to have been put forward as an inference to be drawn from, for example, the mere fact that the shares were transferred without payment.
It would matter in this sense, that if Mr. Kozlov was indeed behind an intra-group transaction at the material time, yes, and that he has now established some kind of control over Evrostroy independently through, we have said in the arbitration, and we've also and repeated it in the courts below, through Ms. Smirnova, who is ostensibly the person who owns and controls Evrostroy, then he would be getting hold of these shares.
How does this affect the variation?
He would be obtaining payment for the shares and taking advantage of a fraudulent scheme.
I mean, it doesn't show, that doesn't demonstrate that there's a variation. If you're going to say that a contract, a valid contract, which required the payment of the price in full, was varied so that part of the price no longer needed to be paid, some evidence has got to be produced.
Well, either I
don't
say
see how it helps to prove that. Who controlled which companies?
in terms of the award, taking a step back conceptually, the award will still stand.
Right. Well, if the award still stands, why isn't it enforceable?
And it isn't enforceable because it it was obtained, procured in circumstances where false evidence was given to the arbitrator, we will say.
I mean, you've got to show, haven't you, you can come to the test, we've slightly taken you out of your route, but in order to resist this statutory demand, you would have to show an arguable case, a seriously arguable case, perhaps, that the award would be unenforceable if an application were made to enforce it in the British Virgin Islands. Is that right?
That's right.
Yes. And one ground would be that it was procured by fraud.
But it would have to be a fraud that was relevant to the liability to which the award gave effect.
Right.
And you haven't, as far as I can see, begun to explain why this fraud is relevant. You haven't begun to explain why, even if one assumes the fraud to have been admitted, it demonstrates that the contract was varied. If the contract was neither varied nor rescinded, then the amount specified in it is due, and there's an end of it.
Could I ask you to turn to page 296, which is also in the award?
Yes. Well, the vital paragraph is paragraph
3.5.
Paragraph
3. It's page 296, and there's a subheading 3.5.
Okay.
Is the SPA tainted by illegality and hence unenforceable as a matter of public policy?
Is the SPA tainted by legality?
The respondent argues that the agreement is tainted by illegality and hence is unenforceable as a matter of public policy. Paragraph 87. The illegality argument is based on the conviction of Mr. Kozlov for fraud. The argument is the claimant has been involved in the fraudulent schemes for which Mr. Kozlov has been convicted.
But why is that relevant? I mean, you can't undermine an otherwise enforceable award simply by saying that there was a bad man behind it. You've got to show that his badness had some bearing on the liability.
The issue is whether or not a British Virgin Islands court should enforce an arbitration award, which was obtained in proceedings in which perjured evidence was given.
Well, perjured
that
evidence on
was
a point which had no bearing on the debt.
Well, in my submission, it would have had a bearing on the issues that are raised in connection with paragraph 87.
But in paragraph 86, where you refer to the agreement, you're not referring to the award, you're referring to the contract, aren't you, the SPA?
And you're relying on the contract. You haven't rescinded it. And it's been
What is illegal? What is your case of illegality in relation to the SPA?
I am relying on the contract, and I haven't rescinded it.
Right.
But
So what's it matter whether Mr. Kozlov, one, existed, and two, was a bad man?
what matters is that the arbitral procedure was tainted by the fraud,
Why is that?
and that because Mr. Bamporia, by giving evidence, blocked Vendort from having the opportunity to argue that Mr. Kozlov lay behind Evrostroy, and that therefore there was an inference could be drawn that the obligation to pay had been varied or waived, which was another way in which it was put
This is
in the
an inference
arbitration.
from the fact that Mr. Kozlov controlled all the companies. That you say that would have given rise to an inference.
It would
There was a
not have been
variation
that wouldn't have
excusing
been
payment of the price.
but that wouldn't have been the only fact. There were other facts which tend to show that he wasn't too troubled about whether or not the SPA was enforced until the other agreements, which would have removed the ISCOG shares from the control of Vendort into the hands of his own companies, Crompton and then Carnarvon, had been set aside. It was only once the first criminal proceedings had been lost that this obligation was sought to be enforced.
So you say that because there was a delay in taking the point, and because Mr. Kozlov, you say, controlled all the companies involved, somebody should infer that there was a variation to excuse payment of most of the price.
I say that if Mr. Kozlov stands behind Vendort, and if Mr. Kozlov sought to divert the ISCOG shares from Vendort by executing agreements or causing the execution of agreements which were fraudulent, then he should be hung up on those agreements, on that fraud.
I mean, that's not good enough for you, because you succeeded in sweeping aside all those agreements. The difficulty is that on the face of it, it leaves you party to the original sale and purchase agreement, under which, on the face of it, you owe a lot of money. You haven't suggested that that original sale and purchase agreement was in any way itself fraudulent, presumably for obvious reasons, that if it was, you'd have to rescind it, or it would be subject to rescission, and it would be the last thing you want. So you've sought instead to argue that the court should infer some variation of it. But I come back to the point I put to you earlier. That's completely inconsistent with the idea that Evrostroy could have thought that it had anything to assign. If there was a variation, apparently for no consideration, I mean, there's firstly a question as to whether that had any validity, or whether there could be an estoppel. But secondly, it's inconsistent with what is quite clear, namely that Evrostroy thought it had something to assign. You say that it was fraudulent in assigning it because it was controlled by Mr. Kozlov and he was doing it for nefarious purposes, and you succeeded on that. But that's a different point. So how does it all fit together?
It all fits together because the SPA is now being used by on my case, is now being used by Mr. Kozlov in order to extract value from Vendort. And if he...
Well, basically, if you pay him, he'll go away. The difficulty is that you want to keep the shares without paying for them. Well, so you've got to find some way of undermining the contract under which you agreed to pay for them, which is now the subject of an award. We're asking, really, what is that way?
Well,
why would Mr. Kozlov, or why could he honestly, why would he sensibly have waived a price when, on the face of it, he intended to enforce the price by an assignment?
If Mr. Kozlov, on our case, Mr. Kozlov was behind Evrostroy at all times. So he tries one fraudulent scheme to get hold of the shares, which it's predicated on the
shares wouldn't work if your case is right, would it? He'd be mad to make a variation because it would deprive him of the opportunity of the assignment on which he was relying, you say, fraudulently, to get hold of the shares, because Vendort was going to then meet the assigned debt by transferring the shares. Your complaint now is, well, we've succeeded in setting all that aside, but unfortunately now we're rather exposed under the original SPA, and we want to keep the shares without paying the original price for them. You've got to show some reason why that is possible, why there's a possible argument that that can be the right analysis. I mean, you can't complain that he wants to claim the price, and no doubt it's right that if he winds you up, he may get control of the company and thereby indirectly of the shares. But that's because the company will have failed to pay the price. I mean, you can't, at the moment, I understand it's seeking to get back the shares from somewhere, and presumably it could, if it got them back, raise money on them and pay the price.
My lord, yes.
So what we're looking for is some plausible case of variation, alternatively some plausible case that any dishonesty in the evidence of a witness in the arbitration really could affect the underlying correctness of the award.
There'd have to be some fraud which explains why the arbitrator concluded that there had been no evidence of a variation. Now, the fraud would have to go directly to that point. And frauds relating to the ownership of the company and all that is just totally beside the point.
The first passage that I read out from the award shows the approach that Vendort had taken in the arbitration.
Which passage was that?
It's
277 or 288?
Page 277. Is about the circumstances on which that's the evidence that it was able to deploy in the arbitration for the purpose of attempting.
The interesting thing is that this award comes after the first set of Russian proceedings. The statements made by Mr. Mamporia during the criminal proceedings against Mr. Kozlov in the district court were precisely the same statements as you now rely on, are they? As inconsistent with statements which he made before the arbitration?
Yes.
So, well, at that stage, the first criminal conviction stood, and so the arbitrator, rightly or wrongly, thought that the contradiction in Mr. Mamporia's account between whether Mr. Kozlov did or did not control Evrostroy was irrelevant.
Mr. Mamporia's story in the arbitral proceedings, when he was cross-examined, was that he had been working for Mr. Koltsov in conducting the business of Evrostroy.
Did Mr. Mamporia give evidence in the criminal proceedings to the effect that there had been a variation of the agreement?
He did not.
Well, that's the end of the case then, based on his evidence. If he didn't give evidence on that point, and there was that does not provide a basis on which you can say that the contract was varied, or that the arbitrator was misled into concluding that there was no evidence of its variation. So you're left with an unrescinded and unvaried agreement to pay the price with which you have not complied.
No, I'm sorry. I probably put a false point to you because in fact, Mr. Mamporia, it may be helpful to look at what Mr. Mamporia actually said in the two criminal proceedings. If you could just help us and try and.
The easiest way into that is to look at the second Russian judgment, which starts at page 653. There's a heading in the middle of page 653. The court has found as follows: Kozlov's guilty of fraud, guilty of collaboration, etc. And then, if we go down to page 674, there's a summary of what Mr. Mamporia said. He called at the request of Attorney Kostanov. He told the court the company Evrostroy was known to him and he was managing director and holder of 100% of the shares of the company, which he acquired without liabilities and assets from the former managing director. It says Kozlov there, but it should say Koltsov. He was aware that the company Evrostroy Grupp acquired from the company Finvest Group shares of AOA ISCOG, and the further shares were sold to the company, Vendort Traders Inc. In this transaction, for the company Evrostroy Grupp, 1/3 of the agreed amount of the contract was transferred, but the remainder was not transferred. So far as he remembers, a trilateral agreement was concluded between Vendort, Evrostroy Grupp, and Crompton. The transaction was found by the Court of First Instance to be invalid. According to Koltsov, he was aware that Kozlov was responsible for the outstanding part of the shares. I'm sorry, I think that's according to Kozlov, not Koltsov.
What do you deduce from that evidence that is relevant to the possible variation?
That evidence takes the matter no further, I think, than the summary, which was that so far as Mr. Mamporia was concerned, when he acquired Evrostroy, he obtained it without assets or
Is that the
liabilities,
evidence that is referred to in paragraph 17 of the award? As evidence of the variation, Vendort offers A, the fact that the shares have been transferred, allegedly waiving the need for total payment, and B, statements by Mr. Mamporia during the criminal proceedings.
No, it can't be, because this is the second. There must be
That must
some
be the
evidence
earlier
in
criminal
the
proceedings.
first.
I see. Right.
The evidence from the first proceedings isn't before the court.
Well, where is the evidence which is referred to in paragraph 17 as having been given by Mr. Mamporia?
That evidence isn't in this bundle.
Sorry, is?
That evidence isn't in this bundle.
I see.
But was it to the same effect as the later evidence? Or was it?
My understanding is that it was to the same effect.
Right.
In the, which was that he'd acquired the company from Koltsov.
But not that there'd been a variation.
No. If you go, in any event, if you go over the page, in the evidence of, in the second Russian judgment, there's the evidence of Koltsov, who was called as a witness and identified, who said that he told the court that Evrostroy, Vendort, and Finvest were not known to him. After the examination of Volume 3, page 105 of the agreement between Vendort Traders Inc. and Evrostroy on the purchase of the shares of ISCOG, the witness Koltsov explained that he was never the managing director of Evrostroy Grupp and didn't purchase the shares. The signature on the agreement wasn't his. And then further down, he says, after the examination of Volume 5, pages 91, 92, authorization, pages 93, standard signatures, the witness Koltsov explained that the signatures on the documents didn't belong to him and he also didn't give the authorization. it then explains his background and how he had come to provide his identity so that it could be used in this situation.
Yes. So his signature on the agreement may have been forged. That was his evidence.
My lord, yes.
But you're not seeking to, as you've already indicated, to undermine that agreement. So where does this take us?
Your problem is that you have established a case for saying that the arbitrator was told that the agreement was at arm's length between Evrostroy, acting through someone called Koltsov, and Kozlov acting at that stage for your clients. So it now turns out, according to the second Russian judgment, that it wasn't at arm's length, and Mr. Koltsov was really just a pawn at the best of Mr. Kozlov. So this is what you call an internal arrangement, or at least one where Mr. Kozlov was acting for both sides. But you still have to show that that means that it wasn't valid. Since you're relying on it, you've got some difficulty in saying it wasn't valid. And you have to show the way in which you seek to show it wasn't valid is not by undermining it, but by saying that it was in some way varied. But that seems to be, for reasons that perhaps I've already put adequately, rather unlikely. Why should we infer that it wasn't intended to be performed according to its terms?
But that's a question, of course, that would be a question for the trial judge to determine, having examined the matter in
At what stage?
Upon an application for the arbitration to be recognised and enforced as a judgment, whether
You haven't ever applied to set it aside in this jurisdiction, have you?
that application wasn't made.
No. But that doesn't.
You don't want to apply to set it aside because you're relying on it.
Set aside.
No, the arbitration award.
You're talking about the arbitration award.
Yes, I'm talking about the arbitration.
There's no application to set aside the arbitration award in this jurisdiction.
No such application was made.
No, but it doesn't have to be, you say, because it's for them to enforce if they want, and you can then apply resist enforcement by on the grounds that it was procured by fraud.
My lord, yes, and also the prima facie, the time limits had expired by the time that the fresh evidence was obtained.
Ought we should look at the arbitrator's reasoning for on this point, just to see whether how your case fits into that.
Yes.
Page 296. The arbitrators, did you really argue that in front of the arbitrator that the sale and purchase agreement itself was tainted by illegality and hence unenforceable?
My lord, I didn't argue this in front of the arbitrator. However, looking at taking paragraph 3.5 on its own, how I understand this is not so much that it's a contract that is in and of itself illegal, but that it's being relied upon by Mr. Kozlov, we say, in order to further his fraudulent scheme, which is to having tried one way to get hold of the ISCOG shares and could take value out of the company, he's trying another way by reverting to this agreement, which he...
But I don't think you can object to someone relying on something which you're relying on.
Not if your point goes to its validity.
Anyway, I mean, I find paragraph 86 pretty difficult. Who did argue the case in front of the arbitrator? Anyone?
Mr. Harris Bohr, who's at Wilberforce Chambers.
I see. Right. But anyway, 87 then seems to go off on a different tack.
87 seems to be saying that Mr. Kozlov being a bad man, the SPA is tainted by fraud. Seems to suggest that was the argument.
And with the added evidence that well, in the second paragraph it says, if there are any such involvement, that would be the signing of the assignment agreement by Mr. Koltsov. If this is the case, then Vendort would have to show that Mr. Koltsov had knowledge of the fraudulent schemes of Mr. Kozlov. Indeed, such knowledge should ideally be shown to be attributable to Vendort. Such evidence does not exist. And of course, that's the very evidence which has come to light by reason of what emerged in the course of the second
But this is pursuant
Russian trial.
This is pursuant not to a variation argument. This is pursuant to some argument, such as my lord saying that everything is so fishy and everyone is so engaged in fraud that what? It's difficult to see where it's going.
Well,
That the SPA is not enforceable, but we're not talking about... anyway, we go back to the round in circles. We're not talking about an agreement which you suggest is invalid, and it's a bit difficult to see how you can, one and the same time... I suppose it is a classic illegality argument, is it, that somehow the subsequent fraud taints this agreement, but, I mean, that must be bad, mustn't it? Because there's no reason why the subsequent scheme which you set aside in the Russian court should taint the original SPA. So perhaps we can put that aside if that's what it's all about. And what about the next paragraph?
According
Come
to...
back to it on any of these points if you want. According to English law, a contract can be vitiated by the illegality of another contract to which it's merely collateral. Well,
That's
that
a
is
rather
the argument.
large statement. I
Yes.
can't believe that
right.
Chitty actually says that.
And then he says, well, it is sort of collateral because it's all to do with the business practices, and the view the business practices of Mr. Kozlov are not closely linked. So, I mean, he seems to be right on that, doesn't he, the arbitrator? If the argument really was that the fraud, which is a subsequent fraud, everyone agrees it didn't begin until over 6 months after the SPA, the sale and purchase agreement, was signed. If it's a subsequent fraud, it is not sufficiently closely related to the sale and purchase agreement to make the sale and purchase agreement unenforceable. So perhaps we can forget the argument that was discussed here. The only argument that seems to be relevant there, if that's right, is the variation argument which we were looking at earlier, paragraph 17.
Going back to the argument that that appears between paragraphs 86 and 89, if we shift the context to and focus on the evidence that has been acquired since the arbitration award was rendered, and look at what is being done now, which is an attempt to deploy the award in the interests of Evrostroy.
What's wrong with that?
What's wrong with that is that effect will be given to the award in the British Virgin Islands when Evrostroy has conducted itself in the arbitration in a way that prevented Vendort from putting the arguments that it wanted to put, from being able to examine the evidence that could have emerged if we've been able to show that Mr. Koltsov was no more than somebody who signed documents, and Mr. Koltsov was in charge. In essence, the jurisdiction is being used to give effect to an award which was obtained by fraud. And at the enforcement stage, the argument would be that the public policy of the British Virgin Islands shouldn't admit of that kind of conduct by recognising and enforcing this award.
Why is it a matter of public policy? Perhaps you ought to show us the relevant section of the ordinance on which you rely. The arbitration ordinance, is it?
The ordinance is, of course, at tab 10.
Yes.
On page 1138, it begins, this is a foreign non-convention award.
Why is it a non-convention award?
Because it's not a New York Convention award.
Why is it not a New York Convention award?
Because of what it says in the ordinance, which is that convention award means an award made in pursuance of an arbitration agreement.
Yes, or the United Kingdom, I see.
Oh, the United Kingdom.
Right, okay, so it's a foreign convention award, yes. So which section are we looking at?
This is quite a simple piece of legislation, which has incidentally been supplanted in 2014 by a much more comprehensive arbitration act. The next relevant provision is section 28 on page 1149, which is for an award or on an arbitration agreement may, by leave of the High Court or other of, be enforced in the same manner as judgment of the High Court. Or, of course, you could have an independent common law action on the award. There's an English case which is in the supplemental bundle of authorities, which I don't think we need to go to, called Dalmia Cement, which recognises that under similar legislative provisions in the United Kingdom, when that was decided, which was...
But is it your submission that until that procedure has been gone through, the award cannot be regarded as enforceable for the purpose of giving rise to a debt?
That is my second ground of appeal.
Yeah, but which is the, assuming that's, putting that aside for the moment, assuming that's wrong, which section of this ordinance do you rely on to enable you to...
There is no section that deals with it. Over the page, we see enforcement of convention awards.
I see.
Of course, it's not a convention award. And then on page 1151, there's a margin heading refusal of enforcement. And there we have a variant of the modern law that's been adopted in this legislation, providing for the convention defences. And under subparagraph, it's 36, subparagraph 3, enforcement of convention award may also be refused if the award is in respect of a matter which is not capable of settlement by arbitration, or if it would be contrary to public policy to enforce the award. My Lord, on an action.
Is there no authority as to what the position was common law apart from the New York Convention when you were trying to enforce a foreign award? Is there no authority which, common law, which outlines the grounds on which you could refuse to enforce it? One would expect them to be I suppose, to be quite close to those in the New York Convention. But
it's basically contrary to public policy is the ground.
Yes.
And you know that's a ground that would have some mileage if there were evidence that there was a relevant fraud. that resulted in the decision being made as it was. But that seems to be your difficulty at the moment.
If this matter were being,
Yes.
in defending an application to enforce, an action to enforce the award, the argument would be made that the award was rendered, so to speak, unsafe by the perjury of Mr. Mamporia. And rendered unsafe to such a degree and in such a way that, as a matter of public policy effect, shouldn't be given to it because it's been procured by conduct that is fraudulent. Of course, to get to that conclusion, one would need to taint Evrostroy with a control, or at least show that Evrostroy was controlled by Mr. Kozlov, who is a bad man.
Actually, you've got in paragraph 46 onwards of the award, haven't you, Mr. Mamporia's, a summary of Mr. Mamporia's evidence, which the arbitrator was asked to accept as pointing, paragraph 46 onwards, asked to accept as pointing towards some variation or waiver.
Yes. So Vendort further relies on the witness statement of Mr. Mamporia, also his witness testimony in the context of the Russian court proceedings. He was a manager of the claim at the time of the SPA. Particular reference is made to the statement that there were no more claims because the company of the claimant was satisfied with the transaction.
Yeah. So, I mean, your case is that the picture presented to the arbitrator was one of two independent companies, Mr. Koltsov acting for Evrostroy and Mr. Kozlov acting for Vendort, who came to an agreement, and then inference was sought to be drawn that there had been some agreement to waive part of the price, whereas you now say that it's quite clear they weren't independent companies, they were all under the control of Mr. Kozlov. And in those circumstances, it is more plausible, you say, that there may have been an intention, Mr. Kozlov may have agreed with himself that the balance would never be claimed. But that's, I mean, that's as high as you can put it, isn't it? Or maybe that is high enough, but that's how, is that how you put it?
That is how I put it.
I mean, how would you propose to get evidence of that? I mean, Mr. Kozlov is never going to give evidence to the effect that he agreed to waive it. On the contrary, his case was that he agreed to assign the debt, which postulates it wasn't waived.
I'm afraid I can't see exactly how I'm going to get evidence of it. I don't know what Mr. Kozlov's position would be in connection with giving evidence in proceedings of the British Virgin Islands.
The difficulty is that let us assume you're right. What is going to happen if this issue is litigated? Is it plausible? Don't we have to consider whether there's a plausible case for the shares being sold as an undervalue? Because your own evidence in the Russian proceedings, which the Russian court accepted, was that 600,000 shares were worth 28 million rubles. So you accept that, I forget how many, the total number of shares was somewhere over 1,000, wasn't it? There were two tranches. There was 800 plus, and then there was another 200 plus, if I'm right. But but your case is that 600,000 roughly were worth 28,000 rubles, so that the full price would be somewhere in the 40s. And yet you say you can get away with paying 15 million. Doesn't seem to sort of make logic.
And I say that I can get away with paying only 15 million because...
But isn't that asserting
because
you yourself?
My ability to... if you take the award as it stands, my ability to not to have to pay arises from the opportunity I lost in the way that the arbitration was conducted to test the case, or in fact, to put my case properly. And I was blocked from being able to do that by the evidence that Mr. Mamporia gave. And I would like to be able to invite a court to find that Mr. Mamporia was in fact no more than the creature of Mr. Kozlov. And Mr. Kozlov stands behind Evrostroy.
So what?
We seem to be going round and round in circles. I mean, as I understand it, your case seems to be that you've got no evidence positive that there was a variation of this contract, but given the sort of general atmosphere of fraud, you hope that if this thing is set aside, something might turn up. I mean, is that what it comes to?
Or you hope that if there were an application to enforce it, because if the statutory demand is set aside, then that's the only way in which it could be enforced, you would find grounds for resisting.
Well, something will turn up, but I mean, that is what you're saying.
I think that I have the evidence on an application for enforcement to show that
this award is
insecure.
Is insecure.
It's unsafe.
Because it was the product of... and you have to say that Mr. Mamporia was the creature of Kozlov in order to attribute the fraud to the party rather than the witness.
And that is something that would have to be tested in the course of the trial.
Yeah.
That's it.
I say that I have the evidence to get there, prima facie.
But I mean, what you're trying to prove is an oral variation of the contract. And how do you get round what the arbitrator said in 74 to 79 of his judgment, where he points out that the SPA required any amendments of the agreement to be in writing? And the argument against this was the oral modification of the agreement modified that provision, which isn't, to my mind, initially an attractive argument. But, I mean, the arbitrator in 79 concludes that there is no evidence of modification or variation of the agreement, even if it did exist. The respondent would have the burden of persuading the tribunal why such oral modification would be valid, despite clause 16.1 of the SPA. I mean, none of this bears on that finding. That, because what, in effect, he refers to the cases that your predecessor put to him and finds them unpersuasive.
The way in which there is room for argument that the provision in the SPA that only written variation would be good enough is not always correct. In fact, conduct by the party against who is said to have consented to the variation that's clear and unequivocal would be sufficient for those purposes. And I think, and World Online Limited and iWay is in fact the authority, the main authority for that.
Which authority, sorry?
Proposition.
It's in
paragraph 75,
yes. World
Online Telecom Limited and iWay Limited. And I'm afraid I don't have that one.
No.
Yeah. again, I would question that Chitty is in fact so unequivocal as it says in paragraph 75. There is room for argument about this.
Thank you.
So in paragraph 79, of course, it says, even if it did exist, then the respondent would have the burden of persuading the tribunal why such an oral modification would be valid. Of course, that's the point. It's the evidence for the oral modification that we were prevented from getting at, as we should have done, had we been able to show that Mr. Kozlos had been Evrostroy.
Is that it on the first point? I mean, you've got a construction point on the section, haven't you, your other point?
Yes.
Can you just help me? There were an additional 268,964 shares transferred. What was the basis for that transfer? They've just treated as part of the original deal, were they, or what? The original deal is specific. It's 834,693. It may not matter, but it just goes to the...
This is explained in the affidavit of Mr. Jones, which is page 254.
Thank you.
Mr. Jones is the gentleman who introduced all this evidence for...
Yes, that's what I was referring to, yeah. He gives a different figure. He says 268,946, but there we are. All the figures are the wrong way around. Does he explain why they were transferred? They were all covered by the same price, were they?
No, there's no further explanation.
And how many shares was it that went down through what you say is through what was found to be the fraudulent chain to Carnarvon and so on? 600 and something, was it? $626,020.
So Evrostroy purchased shares of ISCOG for 44 million rubles. 25th of May, Vendort entered the SPA. On its terms, Vendort bought 834,693 from ISCOG for 44.6, etc., odd million rubles. Evrostroy then transferred transferred 800 that number of shares, and that is the quantity of shares which is in
Yeah.
issue here.
Yeah. I mean, the reason I ask is that your case, putting it again, was in the Russian proceedings and was accepted. That 626,020 shares were worth 28 million rubles. The total price under the SPA was 44.6 million rubles, ostensibly for 834,000 shares, but in fact an additional 265,000 appear to have been transferred without payment, as far as one can see. So, I mean, even if you just took 834,000 for 44 million, that would suggest that 626,000 ought to be worth, well, it ought to be worth more than 28 million. If you took, you as having received 1 million shares for 44 million rubles, then the 28 million value suggests that the value of the shares has gone up. But on any view, these shares cannot be worth, the shares that you've got cannot be worth anything like as little on your own case as 15 million. So you'll be getting an incredible bonus if somebody really agreed to transfer either 834,000 or 1 million, actually 1,100,000 shares to you for 15 million rubles. Is there any answer to that point?
Well, I could look at it the other way
Why
around.
should anyone vary the price to that extent, honestly?
Because of the nature of the transactions. These were intra-group transactions, and the shares were just being moved from a Russian company into a British Virgin Islands company, and the medium for that removal was Evrostroy. And any mismatch in values, or if the transaction values in the SPA could be shown to be at an undervalue, would arguably tend to support the intragroup nature of the transaction.
Right.
But there's no evidence as to what pricing was used.
Right. Should we, unless there's anything more to say on that point, do you want to take to the second point?
Yes, this one should be a bit shorter. Could I ask you to go to the authorities? And behind tab 11, we see the Insolvency Act 2003. And towards the back of that tab, on page 1168, those are the court's powers to set aside a statutory demand.
Yeah.
Say the court will set aside statutory demand for satisfied there's substantial dispute as to whether the debt
Is owing or due.
is owing or due.
I mean, as I understand it, you accept that the test is essentially whether there's a triable issue. In other words, it's the same test as in an application for summary judgment.
That's correct.
But if you look at the test in 1571, there has to be a substantial dispute as to whether the debt or a part of the debt sufficient to reduce the undisputed debt to less than the prescribed minimum is owing or due. Now, ultimately, you depend on a variation of the agreement to meet the second A2 heading, because even if the arbitral award, the additional sums because of the arbitration weren't due because of some dubious aspect of the arbitration award, there is still the SPA, and there's still a substantial sum due under the SPA, and that aspect of the arbitration award is not being impugned unless you can establish a variation. Is that not the case?
My point on this aspect, on this ground of appeal, is much simpler than that. It's just about literally the construction of this statute.
Yeah, but I think my lord was asking you probably a point which you should answer in relation to the previous
first one.
ground you've
Yes.
been arguing. I mean, isn't his point right that there are two potential debts here? There's the original debt and there's the arbitration award.
My lord, yes.
Yes, and if you can't show, if the substantial dispute doesn't show that there is that there is not a debt sufficient to fall, there remains a debt sufficient to stay above the prescribed minimum owing, then it's really irrelevant whether one's enforcing the arbitral award or not.
I mean, there's no doctrine of merger in relation to arbitration awards,
No.
as I understand it. That's right, isn't it?
As I understand it too.
Am I right that ultimately you have to say you've been deprived of establishing your variation? That has to be your key point.
The way in which this is dealt with in the BVI authorities in connection with winding up, and it's the two.
Yep, you're coming back onto the second, sorry, whichever way round it is, you're coming back to this point you want to argue second, but my lord's asking.
So I've taken you away from your second point at this stage.
Yeah,
I'm the first point.
I'm happy to go back to the question that was put to me, and then I'll.
I mean, the
move on
fact
to my
is that
second
if
point.
we just looked at this, as my lord is inviting you, as an application to enforce the original SBA debt, you still haven't got any real evidence of variation at all. And the only point you can make is that only 1/3 of the price was ever paid, but that doesn't mean to say the balance was forgiven or waived, or that's the problem, isn't it?
The problem is whether or not what this provision enables me to do
Right. Yes, let's look at this. If you want to look at the provision, how does it link up?
is
with
to argue that is to say that there is a substantial dispute.
We're asking whether it's substantial. Why is it substantial?
Well, it's I think in the sense of anything other than flimsy. It's
Yes.
there's BVI authority on that, which is in the authorities bundles. And in fact, these are reverted to in the judgment anyway as to what the appropriate test
Yes.
is.
We have had two careful judgments below which have concluded that there isn't anything other than a flimsy dispute. That's something we give some weight to when they're concurrent on the point, but anyway, this is the test, and do we get anything more from the authorities? Refer us to them if you wish, but you've indicated what the test is, you say?
Yes.
We're still on the first point now, we've got to the second point.
I think we're on the second.
Second point.
We're on the second point, yes.
Yeah.
If I could ask you to go to the first authority in the bundle of authorities, which is Grand Pacific against Pacific China Holdings, and that's a judgment of Justice Bannister at first instance.
Yes.
It was held subsequently, when this was appealed, that he was right in his approach to this, to the problems in the case, down to paragraph 14. In that case, there was a Hong Kong award on a New York law agreement, which was sought to be sought as evidence of debt in the context of a winding up petition. And the approach that the court took was to accept that this was really that an application to enforce is, in fact, analogous to an application to wind up a company on the basis of a debt. And that is explained, just go to paragraph, to page 880, paragraph 3. 1, 2, 3, 4, 5 lines down. At the end, there's the word the. The applicant has not taken steps to convert the award into a judgment, nor has it taken any steps by way of enforcement. It requested the company to honour the award. The company hasn't done so. On the 11th of November, the applicant issued his application. No statutory demand has been served. The grounds for the appointment are that the applicant is a creditor of the company, and the company has failed to pay its debt to the applicant under the award as it fell due, and the company is therefore insolvent. The company, which is facing winding up, argues, and this is set out at the next page, 881, paragraph 5, that the award is open to challenge, either in the courts of Hong Kong or indirectly in the course of any proceedings the applicant might take to enforce. He says the grounds on which the award is challenged by the company mean the debt is disputed. I'm not sure that that is correct. Until and unless the award is set aside, its existence and therefore the existence of the debt which it affirms cannot, it seems to me, be disputed. At the time of the hearing, the company has made no application in Hong Kong to have the award set aside, although I fully accept that for the time, that time for the company to make an application is still running. It's true that in enforcement proceedings, the court, before which enforcement was sought, might refuse on one or more of the well-named grounds of which to apply the New York Convention awards and permitted to be enforced, but that would be obtained, but that would be because the court found something objectionable in the process by which the award had been obtained or declined to enforce it on public policy grounds. And then he goes on to say, the award, however, would stand, only its enforcement would be refused. So that it seems to me that as things stand, the debt itself cannot be disputed.
Yes, but he goes on to say that you apply the substantial grounds test. It seems to me we are drifting back to the first point. This simply goes to the standard of proof or evidence which is necessary in order to show that there's a dispute.
Yes.
I thought your second point had to do with section 10.3 of the ordinance and was to do with the question whether they could enforce an arbitration award without, well, by a statutory demand, without first enforcing it as a judgment in the BVI. That's a point which actually would disappear in the light of Lord Hodges' reference to the fact that the SPA gives rise to a debt. But aren't I right that your second point is nothing to do with this case, Pacific China, which really relates to your first point?
That's correct. Well, Pacific China explains the context in which the...
Explains the test we apply on the first point, which is helpful. I think paragraph 6 says that although strictly the award is an award, nonetheless, you wouldn't allow a statutory demand under the company's legislation if there were substantial grounds why the award would not be enforced if an application had been made to enforce it as a judgment.
My lord, yes.
Yes. Or to sue on it, I suppose.
Well, the only answer that I can make to the point about the answer that I do make to the point about enforcement on the basis of the SPA is enforcement being sought on the basis of the award, and the question is whether or not there is therefore a debt.
I think, where is the application for enforcement? Is it based exclusively on the award?
The statute of demand.
Yes, the statute of demand. But
It's page 268 in volume 3. And it is based on the, and 269 it's based on the arbitration award.
so,
But for the first paragraph is the sum balance due and payable under the SPA.
Yes.
And then there are the further sums of interest and then the arbitral costs.
but I mean, we're probably entitled to, in considering whether we should refuse enforcement, to have regard to the fact that there is an underlying debt which is, on the face of it, challenged, but we have to consider whether it's challenged on substantial grounds.
Well, it comes down, it would come, the hypothesis, as I understand it, is that the statute of demand would have been issued simply on the basis of the SPA, and the award would never have been in.
Well, it might come down to this. I mean, why would you refuse enforcement to an award on grounds which, even if they'd been available to the arbitrator, would not on their face have led to any different award? I mean, he may have been misled by some evidence, but we have to consider whether the evidence would have made the slightest difference.
It may very well, if what came to be known in the second Russian proceedings had been known at the time of the arbitration, then the case would have been put differently, and opportunity, etc. So it's the same reasoning applies in this situation.
Well, would you like to go to your second point insofar as there is one?
If I can ask you to turn to page 1162. Where it says under 10.1, I think that for the purpose of this Act, liability means a liability to pay money or money's worth, including a liability under an enactment, a liability in contract, tort, or bailment, a liability, etc. And liability includes a debt. There's the important words. And then down to sub 3, for the purposes of this Act, an illegal or unenforceable liability is deemed not to be a liability. And then over the page on, if you move forward to page 1166, the statute of demand, a creditor may make a demand on a person for payment of debt owed by that person to him. A demand under section 1 shall be in respect of a debt that is due and payable at the time of the demand, and that is not less than the prescribed minimum.
Right.
And the second point really just is a standalone point, which is that unless and until the arbitral award has been recognised as enforceable, then it's an unenforceable liability. And if it's an unenforceable liability, then it won't support a statutory demand.
Yeah.
There's also, of course, the point that an arbitral award is enforced on the basis of the parties' promises, the promise that an award will be rendered will be paid. So it's like a breach of contract rather than, in fact, a debt. So an action on the arbitral award yields a judgment which is equivalent to damages rather than debt.
There's no authority for that proposition, is there?
Well, there is authority to that proposition, but it's quite... it's in the supplemental bundle in Bremer Earl Transport.
Which tab?
Sorry, it's tab 14. So,
Sorry, which is the passage in it which is...
I'm just looking for the... I do apologise. So on page 758, sorry, internal page 758, it's a bundle 1207. The paragraph at the bottom, I therefore proceed to consider the case on behalf of the plaintiffs of this award on which they seek to sue or raise in respect of a contract made within the jurisdiction. The contention raises at the outset the following juridical problem: what is the nature of an action based on an award?
Yes.
And he then goes through the older authorities, and he notes that in the past an action on an award could be characterised as an action in assumpsit and debitatis, but that that was, but eventually he concludes that that the contractual analysis is to be preferred.
Where is that?
So on page 763, the last paragraph, as I understood the argument of Sir Robert Aske, he asks us to consider the present action to be analogous to the old action of debt on a bond conditioned to perform an award. But the action in the present case can't possibly be brought within the observation of the court in such cases as Stillion, Polverferra and Oven, where it is said that by declaring on the bond the plaintiff need not...
Does this have anything to do with damages? It doesn't seem to me that this case is on the point. The point seems to be where was the breach in failure to pay the award sum, rather than whether the claim lay in debt or damages. If anything, it seems to assume it was a claim in debt, but I'm maybe wrong.
I think it's 765, second full paragraph. He concludes that this is an action for the enforcement of a contract made within the jurisdiction.
Yes.
So he analyses the enforcement of award as the enforcement of a contract.
Yeah.
The contract being to honour the award.
Yeah.
Yes.
Right. So, anyway, what is if that's? Is there any other authority? This is not a claim in debt. And
my lord, I don't have any other.
no, what about your point that it's not enforceable because you have to enforce it in terms of what? Getting a judgment, or?
Well, it has to be, in order for it to be a debt, under the legislation, under the statute.
Yes.
It has to have been rendered enforceable in the jurisdiction.
Well, authority is against you on that, isn't it, insofar as there is any? Do we not have the Pacific King shipping case?
That authority is against me.
Is there any authority in favour of you on that? Both courts below have consider this, and is there any authority which they have missed?
No, I simply rely on the wording of the statute.
The wording of the statute, yes.
My Lord, can I have one moment? Is there anything more? I have no further submissions.
We're grateful to you for dealing with the case and answering our questions, and the board will take time to consider what advice it will humbly tender to